All right, Crystal Cranfield.
Judge, that's on the docket today for plea. We have a disposition in that case. In this case, Ms. Cranfield's charged in 2 indictments. In case 2022 CR 13, she's charged in a 10-count indictment. She's going to enter a plea of no contest to count 1 and count 9. That would be possession with intent of Schedule 2, receive a sentence of 10 years in TDOC, be fined $2,000 on each count. Those counts will be concurrent. Forfeit all contraband and seize property to the Drug Task Force. Count 2 through 8 and 10 will be dismissed in settlement. I've listed the jail credits on the sheet, and that'll be a range 1 30% sentence, Judge.
She will serve the sentence, though. Is it service?
It is to serve.
All right, Ms. Cranfield. Sorry.
You want me to get to the other one?
Yeah, you're going to nolly the other one.
Yeah,
right?
we're okay.
Okay. It was just one step ahead. All right, Ms. Cranfield, if you raise your right hand, let's place you under oath.
Yes, ma'am.
State your full name for the record.
Crystal Lynn Cranfield.
Ms. Cranfield, you're here in 2 different indictments, but it's been indicated you're going to be entering a plea to 2 counts on 1 indictment. All the rest of those counts are going to be dismissed, and then the other indictment will be dismissed outright. But have you seen or been shown a copy of those charges and talked over with Mr. Baker? You
Yes,
and he
sir.
discussed the range of punishment you're facing as well as any possible defenses you might have.
Yes, sir.
Well, it's indicated that you want to enter a plea of nolo contendere or no contest. Do you understand that simply means you understand what the evidence is against you? You're not going to admit you did anything wrong, but you're not going to contest the state's version of these events, and I'm going to rely upon their version to find you guilty according to this agreement. You understand that? Do you understand, however, that you have a right to plead not guilty and to have a speedy and public trial by jury?
Yes, sir.
You understand that if you went to trial, you would have the right to have a lawyer and to have one appointed if you could not afford your own. You understand that at trial, you would be presumed to be innocent until such time, if ever, the state proved your guilt beyond a reasonable doubt to the satisfaction of all 12 jurors, and their verdict would have to be unanimous before you could be convicted of anything.
Yes, sir.
You understand that if you went to trial, you and your lawyer could confront and cross-examine all witnesses the state called to testify against you, and you could bring in your own witnesses by using a subpoena.
Yes, sir.
You understand that if you went to trial, you would be presumed to be innocent. You would not have to testify or prove anything, and no inference of guilt would arise because you did not testify at your own trial.
Yes, sir.
You understand if you went to trial and you were found guilty, you could appeal that conviction and the sentence imposed to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal.
Yes, sir.
Do you understand that by pleading no contest under this agreement, you're waiving your right to a trial and to an appeal, and all I'm going to do is to approve what your lawyer has worked out. You understand that?
Yes, sir.
But that's going to result in 2 Class B felonies that are going to be on your record in the future to make more severe any punishment you will receive in the future if you're again convicted of a crime.
Yes, sir.
Now, there's going to be 10 years for you to serve. Now, I understand and you understand that you're going to get pre-sentence jail credits, but beyond that, it'll be up to the Department of Safety as to how much of that sentence you actually serve. It's unlikely you're going to serve the entire 10 years. We all know that. But the sentence I'm giving you is 10 years. So good time, other credits that the department gives you other than your pre-sentence jail credit are not a part of this plea agreement. You understand that?
Yes, sir.
All right. You understand everything I've explained to you thus far?
Yes, sir.
Do you want to enter a plea of no contest and waive your right to a trial and to an appeal?
Yes, sir.
Do you understand, is your decision rather to plead no contest today voluntary?
Yes, sir.
Anybody forcing you to do this against your will? Do you understand I can't accept your plea unless I'm satisfied there is a factual basis for it and that you are in fact guilty?
Yes, sir.
And I want you to listen as the state tells me what their evidence would be if this case went to trial. You know?
Your Honor, if this case had gone to trial, the state would put on evidence to show that there was various information given in regards to Crystal Cranfield selling methamphetamine. An investigation began. There were undercover agents that were working with the Drug Task Force that made purchases from Ms. Cranfield, including one of those purchases of methamphetamine on March 2nd of 2022. Later on, more investigation happened. A search warrant for a tracker was placed on her vehicle. Officers conducted surveillance and observed Ms. Cranfield driving to Nashville on multiple occasions to meet with her source. She then came back to Dixon County At one point in time, she was stopped in Dixon County on May 20th of 2022. At that point in time, she had over a pound of methamphetamine in her car and was actively attempting to destroy it at that point in time of the stop. That would be the evidence the state would present.
Ms. Granfield, I'm not asking that you, but do you understand that's what the state's evidence would be if this case went to trial?
Yes, sir.
You still wish to plead no contest to those facts?
Yes, sir.
Are you satisfied with your attorney's services?
Yes,
You
sir.
feel like Mr. Baker's done a good job of representing you competently? Mr. Baker, you know of any reason she should not enter this plea?
I do not, Judge.
Then Crystal Cranfield and anything further from the state, I'm sorry.
No, Your Honor.
Then Crystal Cranfield and docket number 2022 CR 213, upon your plea of no contest to count one, I find you guilty, sentence you to 10 years, Tennessee Department of Corrections, and a $2,000 fine. Count 9, you found guilty, sentenced to 10 years in Department of Corrections and in order to pay a $2,000 fine. Also forfeiting any contraband and seized property. All the remaining counts 2 through 8 and 10 are dismissed as a part of this. Your pre-sentence jail credits are set forth on this document. In docket number 2022 CR 214, your case is dismissed on the state's motion as a part of this agreement. You're remanded to the custody of the Department of Corrections to begin your sentence. Nicholas Shane Dugan.
Judge, in this case, I'm standing in for Mr. Belmars. Mr. Belmars represents Mr. Dugan. They have reached an agreement with the state in which in 2022 CR 213, which was the companion case where Mr. Dugan was co-defendant with Ms. Cranfield, he is going to receive a sentence of 12 years TDOC as arranged, 2 multiple offenders suspended to community corrections. After 180 days, pay a $5,000 fine and the court costs, forfeit any interest in any seized property in this case. It'll be concurrent with 2022 or 2014 CR 449, and the balance of the sentence after jail credits, which are listed on the sheet, will be served on weekends. And he works for the help center, and I think they're going to skip the second weekend of each month. And I believe there's a companion VOP in this case. That's 2013 764, 2014 CR 115 and 149. Mr. Dugan will be reinstated to community. She's actually going to be transferred to community corrections on this case. She'll be reinstated. And the 764 and 115 actually have expired. So the 449 remains open. I think that's the one that's concurrent to the 213 case.
Sorry, I can't hear anything she's saying. General Wojnarowski is saying.
Right, I'm sorry, I forgot that Ms. Kim was on Zoom. So what I was saying is that there have been multiple violations, multiple sentences in which Mr. Dugan was on violations, as well as violations that ran consecutive to other violations previous to this pending case. And we're trying to clear that up so that everybody is of the understanding that 2014 CR 449, I believe there were 2 counts in that case, that remains open and active, and that all the other previous sentences have expired with the credits that he has on those. So then all the credits that he's earned from violations will have gone to those sentences. And then on this one, the 2014 CR 449, he will have credits for some community correction street time, as well as he successfully completed DC4, so he'll have some credits on those. But all the rest of the remaining credits and jail credits went to the other violations that were listed. And then he'll have this new sentence in which he's only entitled to credits for his jail credits from the 9/3/2022 to 12, is that 12/1 of 2022? And that's on 2022 CR 213.
Now, I just have one question. This is a 12-year sentence that he's being suspended after 180 days, but the rule used to be that anything above a 10-year sentence could not be probatable. Is that?
Oh, there's been some question, Judge, in regards to, at least within our office, as to whether or not that applies just to probation or community corrections.
Well, probation is different than community corrections because community corrections is actually a sentence to be served. It's just being served in the community. But I wanted to address that because it does appear that we're suspending a sentence to community corrections and we're calling it community corrections probation, but we don't think that's going to violate the 10-year limitation.
I'm hopeful not, Judge, only for the fact that when we're dealing with this, we're dealing with his other community corrections or other violation sentence that previously had been imposed prior to this rule coming about, in which he had had an 18-year sentence. So we're trying to make this all work in conjunction to his previous sentence that was done before the rule took place, if that makes sense. And with the jail time, it will reduce, obviously, the amount of time that he would be on community corrections.
All right.
Credit, of course, he got as well.
I assume there are compelling reasons why if with that type of prior record, why we're again giving him some sort of probatable offense.
Yes, Judge.
We don't have to go into it on the record, but I just wanted to acknowledge that there must be something aside from the normal case that would allow us to do this.
Yes, Judge.
All right. All right, Mr. Dugan, raise your right hand. Let's place you under oath.
Yes, ma'am.
State your full name for the record.
Nicholas Shane Dugan.
Mr. Dugan, you're here today on two different types of cases, and I want to deal with your probation violation first. Do you understand that you have a right to plead not guilty to that charge and to have a hearing in this court where the state would be required to prove to the legal standard that you had violated your probation?
Yes, sir.
You understand that if we had that hearing, you would have the right to have a lawyer and to have one appointed if you could not afford your own.
Yes, sir.
You understand that if we had the hearing and I found you guilty, you could appeal whatever I did in your case to the Court of Criminal Appeals, and you would have the right to have a lawyer appointed to help you with that appeal.
Yes, sir.
You understand that by pleading guilty to that charge, you're waiving your right to that hearing and to that appeal. All I'm going to do is to approve what your lawyer has worked out, which is basically to reinstate you to probation on time served, but transfer you to community corrections. You understand that?
Yes, sir.
You understand everything I've explained to you?
Yes, sir.
Do you want to waive your right to a hearing and to an appeal by entering a plea of guilty to the violation of probation?
Yes, sir.
Then I find you guilty, or that you be revoked to serve your sentence. However, by agreement with the state and your lawyer, I will reinstate you to probation, but transfer the remainder of your probation to community corrections. And the provision that General Wojnarowski was talking about, all of that is noted on this document, and therefore it will be a part of the record as well. Now we're moving to the new charge. You are charged in a multi-count indictment, but it's indicated that you're going to only plead to one of those counts, and you're going to plead no contest. But have you seen or been shown a copy of those charges, talked them over with Mr. Bellmeyers? And do you feel like you fully understand what you're charged with, what the range of punishment is, and any possible defenses you might have?
Yes, sir.
Well, it's indicated that you want to enter a plea of no contest or nolo contendere. That means, as you heard me explain, you are not going to admit you did anything wrong. But the state is going to tell me what their evidence would be at trial, and you're not going to contest that. And as a result of that, I'm going to find you guilty according to that evidence. Do you understand that?
Yes, sir.
Do you understand, however, that you can plead not guilty and have a speedy and public trial by jury?
Yes, sir.
You understand if you went to trial, you would have the right to have a lawyer and to have one appointed if you could not afford your own.
Yes, sir.
You understand that if you went to trial, you would be presumed to be innocent until such time, if ever, the state proved your guilt beyond a reasonable doubt to the satisfaction of all 12 jurors, and their verdict would have to be unanimous before you could be found guilty of anything.
Yes, sir.
Do you understand that if you went to trial, you and your lawyer could confront and cross-examine every witness the state called to testify against you, and you could bring in favorable witnesses of your own by the use of a subpoena?
Yes, sir.
You understand you would not have to testify at trial, you wouldn't have to prove anything, and there would be no inference of guilt that would arise because you did not testify at your own trial.
Yes, sir.
Do you understand if you went to trial and you were found guilty, you could appeal that conviction and the sentence imposed to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal?
Sir.
Do you understand that by pleading no contest, you're waiving your right to a trial and to an appeal? All I'm going to do is approve what your lawyers worked out. Do you understand that?
Yes, sir.
Do you understand that that's going to result in a felony conviction that's going to be now on your record to enhance or make more severe the punishment you'll receive if you are ever again convicted of a crime?
Sir.
You understand all of the rights that I have just explained to you? Do you wish to plead no contest and give up your right to a trial and to an appeal? Is your decision to plead no contest today voluntary?
Yes, sir.
Anybody forcing you to do this against your will? Do you understand I have to have facts presented to me that will allow me to find you guilty? And I want you to listen as the state tells me what their evidence would be if this case went to trial.
Your Honor, if this case had gone to trial, the state would have put on evidence to show Mr. Dugan was a co-defendant on some of the counts involving Ms. Cranfield, who just pled. Obviously, the court just heard the facts in Ms. Cranfield's case where there had been investigation that was taking place, observing her. During the time that they were observing her, they observed her in vehicles that belonged to Nicholas Shane Dugan. Mr. Dugan and Ms. Cranfield were in a relationship at that point in time. After they found Ms. Cranfield with a pound of methamphetamine in the vehicle that she was driving, they executed a search warrant on the residence. That residence was a residence that was owned by Mr. Dugan, but was shared by Mr. Dugan and Ms. Cranfield. And in that residence, they did locate approximately 19 grams of methamphetamine in the master bedroom. There were items within the home to show that both Ms. Cranfield and Mr. Dugan were residing in that home.
All right, I'm not asking that you agree with those facts, but do you understand that's what the state's evidence would be if this case went to trial?
Yes, sir.
You still wish to plead no contest?
Sir.
Are you satisfied with your attorney services?
Yes, sir.
I feel like Mr. Bellmeyers has done a good job of representing you confidently.
Yes, sir.
Mr. Baker standing in for Mr. Dugan, I'm confusing Leonard Bellmeyers and Mitch Dugan because of your client or Mr. Dugan's last name. Do you know of any reason that Mr. Dugan should not enter this plea?
I do not, Judge.
Anything further from the state? The Nicholas Shane Dugan and docket number 22 CC 2022 CR 213. Upon your plea of nolo contendere to count 6, all the remaining counts are dismissed. I find you guilty, sentence you to a plea of no contest. I find you guilty, sentence you to 12 years in the Tennessee Department of Corrections as a range 2 multiple offender, suspended to community corrections after 180 days. $5,000 fine and court costs. You are to forfeit all interest in the items seized in this case. This will be served concurrently with 22 CC 214 CR 449. Any remaining time that you have, it looks like about 90 days. So all remaining time that you are to serve will be served day for day and maybe on the weekends with the exclusion of the second weekend of the month so that you can maintain your job at the health center. He needs to see the probation department. What weekend will he begin serving that? This weekend?
No, sir. We got a food drive tomorrow. It's the second
This
Saturday.
is the second weekend. Okay, so it won't be that tomorrow the food drive is taking place. It'll be the next weekend. All right. Twenty 24 CR 118 State versus Amanda Christine Hollis. You have a bond for her? Do what? And you said there's a warrant for her. Do we know what that warrant is for? All right. Well, there'll be a conditional forfeiture of her bond in the amount of $5,000 on the one case. Capias for the defendant. Sorry, facie to the bonding company set up for May 27th for final forfeiture. And the new bond will be $25,000. Well, actually, we're going to issue a capias on the others that had OR bonds. She's going to be required to make a bond on all of those. $25,000 plus $5,000 on each of the other two. So that would be a total of $35,000. So. It was on the, wasn't that one on the 2024-118 theft of property? That's right. That's the one that's going to have a $25,000 bond, and then all the others will have a $5,000 bond on each of them. Okay. All right. Thank you. Twenty 2023 CR 83, State of Tennessee versus Josiah Lewis. There'll be a conditional forfeiture of the bond in the amount of $4,000. Sour facie of the bonding company set for final forfeiture on May 27th, 2025. Capias for the defendant's arrest. New bond will be $25,000. (2020) CR 127, State versus Melody McKinney. Good morning.
Sir, on Ms. McKinney's case here, she is in treatment at Synergy Treatment Centers, and I received a status update from probation. It's dated 11/20/2024, November 20/2024. She is doing well in her program. She is in her 10th month of treatment. It's got a projected completion date, Your Honor, of January 2, 2025. Her most recent drug screen was November 13th.
You want to put it on January 27th, which is VOP day?
That'd be great.
January
Yes, thank you, Your Honor.
27th.
I'm handing up the copy
That
of
actually,
that.
we have a copy of that they sent to us. So.
Yes, sir. Thank you, Your Honor.
2020 CR 150, State versus Carl Reeves Northington. Mr. Howard?
We've reached a resolution in this case in which Mr. Northington would be entering a no contest plea to counts 1, 2, 3, and 5. Counts 4 and 6 will be dismissed in settlement. Regarding count 1 and 2, that'll be a 1 year to serve determinate release sentence. He mainly has the credit for that. It's past his determinate release. He will need to go into custody and wait for TDOC to process that. On counts 3 and 5, he'll be sentenced 8 years suspended to probation consecutive to count 1 and 2, and 6 months suspended concurrent with count 3 on count 5. He will be fined $100 and forfeit all items seized to the drug task force. Does have pretrial jail credits in the amount of 120 days.
All right, Mr. Northington, raise your right hand. Let's place you under oath. State your full name for the record. Just step up to that microphone, please.
Carl Reeves Northern.
Mr. Northington, you're here today on a multiple count indictment, but you've heard your lawyer go over what the agreement is. But have you seen or been shown a copy of those charges, talked them over with Mr. Howard, and you and he discussed the range of punishments you're facing as well as any possible defenses you might have?
Yes.
While it's indicated that you want to enter a plea of nolo contendere, you are well aware that that means you're not going to admit you did anything, but you're not going to deny or contest what the state's evidence is that they're going to tell me about. And then I'm going to use that evidence to find you guilty of these charges. You understand that?
Yes.
You understand that you can plead not guilty and have a speedy and public trial. We were scheduled for trial today. You understand that?
Yes.
You understand that you would have the right to have a lawyer and to have one appointed, as I've done with the public defender.
Yes.
You understand that if you went to trial, you'd be presumed to be innocent until such time, if ever the state proved your guilt beyond a reasonable doubt to the satisfaction of all 12 jurors, and their verdict will have to be unanimous before you could be convicted of anything.
Yes.
Do you understand that if you went to trial, you and your lawyer could confront and cross-examine every witness against you, and you could bring in your own witnesses by using a subpoena?
Yes.
You understand that you would be presumed to be innocent at trial. You would not have to testify or prove anything, and no inference of guilt would arise because you did not testify at your own trial.
Yes.
Do you understand that if you went to trial and you were found guilty, you could appeal that conviction and the sentence imposed to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal?
Yes.
You understand that by entering this plea, you're waiving your right to a trial and to an appeal. All I'm going to do is approve what your lawyers worked out.
Yes.
You understand that's going to result in multiple convictions, some of which are felonies, and one of which is a misdemeanor, but those are going to be on your record in the future to make more severe the punishment you will receive, rather, if you are ever again convicted of a crime. You understand that? You understand everything I've explained to you?
Yes.
Do you want to plead no contest according to this agreement and waive your right to a trial?
Yes.
And is your decision to plead no contest today voluntary? Anybody forcing you to do this against your will? You understand I can't accept your plea unless I'm satisfied that there is a factual basis for it and that you are in fact guilty.
Yes.
Now, I want you to listen as the state tells me what their evidence would be if this case went to trial. General?
On April the 20th of 2022, Agent Morrison with Drug Task Force observed Mr. Northington stumbling in the roadway. When he identified himself and asked Mr. Northington to stop because he thought he might be under the influence and was checking on his safety, Mr. Northington went away from him and also made quick movements at the waistline. When Agent Morrison did make contact after a brief foot pursuit, he was forced to use force to get Mr. Northington into custody, and Mr. Northington continued to resist. Once he was searched, Mr. Northington had a loaded revolver in his possession, and he is a convicted felon with prior crimes of violence, including assault with intent to murder and aggravated robbery. After the arrest, Mr. Northington continued to make threats against task force agents Freeze and Morrison, and threats to do harm to their family members.
All right, I'm not asking that you agree with those facts, but do you understand that's what the state's evidence would be if this case went to trial? You still wish to plead no contest according to this agreement? Are you satisfied with your attorney's services?
Yes.
You feel like Mr. Howard's done a good job of representing you competently?
Yes.
Mr. Howard, do you know of any reason you should not enter these pleas? Anything further from the state?
No, Judge.
Then Carl Reeves Northington and docket number 20, CC 20, all right, CR 150, upon your plea of no contest to count one, I find you guilty, sentence you to 1 year to Department of Corrections to serve on determinate release. Count two, you're sentenced to 1 year to serve, also will be concurrent with count one. Count three, you're sentenced to 8 years, Tennessee Department of Corrections, suspended of probation, but consecutive to counts 1 and 2. Count five, you're found guilty, sentenced to 6 months, suspended, but concurrent with counts 3 and consecutive to counts 1 and 2. And you're ordered to pay a $100 fine and costs and forfeit the seized items to the Drug Task Force. Counts 4 and 6 were dismissed as a part of the agreement. So Mr. Northington is remanded to the Sheriff's Department to begin serving a sentence, what's left of his sentence. All right, thank you. All right, do we have anything else? Oh, I thought it was on page 404. So we have a page 101. All right. This is 2023-0266, State versus Leah Marie James. We need to set a new date of all right, I've recused myself from that case, so we need to have a new date set in front of one of the other judges.
We could do March 13th if the court, that works. I think that's Judge Lockhart Mash. And the plea date is March the 10th.
You have a card you can, Misty, you have a card you can give the defendant. Right, March 10th for the pleas, March 13th for the trial. Same thing for Mr. Zurich,
Yes, Judge.
3/10, 25, 3/13 for the trial. All right. Well, that concludes our business for today, so we will